Pleased to be joined now on the Newsline by Amy Swear. Ms. Swear is a senior legal fellow at Advancing American Freedom, specifically within the Edwin Meese III Institute for the Rule of Law. You learn much more about all the activities of this group online, advancingamericanfreedom.com. Ms. Swear, good morning. Thanks for taking the time.
Good morning. Thank you so much for having me.
We have spoken to folks from Advancing American Freedom in the past, but if there's a listener who has missed those conversations, kindly tell us. AAF, who are you folks and what do you do?
We are a conservative public policy think tank in Washington, D.C., based in traditional conservative public policy principles. So the way I like to explain it is we try to help the government understand how to be better at its job. And help just ordinary Americans understand from a conservative standpoint what good public policy and the rule of law looks like.
And in most cases, that has to do with, well, I don't know, check the Constitution, check the statutes, follow those things. And that's what led me to want to have this conversation, because the U.S. Supreme Court last week handed down a unanimous decision. And I may be missing it, but given how divided the court is these days, when was the last time there was a good 9-0 decision, especially when it had to do with the Second Amendment? Tell us about this case, please.
Well, you're right. It has been a while since the Supreme Court, especially on a gun case, has been so completely united in telling the government that the government was wrong. So this is a case that I think a lot of people have gotten this wrong. So it is about marijuana use and the ability to keep and bear arms. But it doesn't go so far as to say, well, anybody can use any drug they want and still run around with guns. So it sort of splits the difference. So this deals with a federal statute that disarms people who are, what the statute says is unlawful users or abusers of controlled substances. Now, I know a lot of people might hear that and they're like, well, that sounds like a good idea, right? That if you're a cocaine addict, maybe you shouldn't have guns. But in this case, you had Mr. Hemani, who the only evidence against him was that he admitted, well, I smoke marijuana, a couple of times a week. And the government said, well, on that alone, you're automatically disarmed. We're going to criminally prosecute you. You lose your right to keep and bear arms. And more than that, at oral argument, the government took this very, very broad approach to this, basically saying that we don't have to prove anybody who uses any drug is dangerous. And it doesn't matter what drug they use. Anything that the federal government, through the Controlled Substances Act, has ever regulated, if you are using any amount of that drug for any reason other than, what it was prescribed for, well, then you lose your right to keep and bear arms. The end. We don't have to actually prove that it made you dangerous. And the problem with this is that it went so broad that the government actually admitted to Justice Barrett that, yes, Justice Barrett, if you take your husband's prescription Ambien a couple of times a month to help you sleep, you are, by that alone, dangerous, and we can disarm you, and we don't actually have to prove it made you dangerous. Which you can understand how that could be a problem, right? Because there's a wide gulf between, that situation and someone who, just to throw this out there, right, like a Hunter Biden scenario where he was a cocaine addict routinely using alcohol, right? Mm-hmm. And so at the end of the day, what the Supreme Court said was the government has to prove that the person that they want to disarm is actually dangerous because of their substance abuse, because of their unlawful use of marijuana. So they don't even necessarily say that the government couldn't have proved that Mr. Hemani was dangerous because he smoked marijuana every other day. But they couldn't just categorically say, well, because he smokes marijuana every other day, then he's dangerous. So it really, I think, puts the burden on the government to prove that at their core, the person they want to disarm is specifically dangerous, and they have to do it every time.
There are various corollaries or similar situations where if you violate a certain statute, then it impacts other freedoms that you may have. So, for example, if you are picked up in the state of Iowa for drug use, you may lose your driver's license. Well, it's a different standard because you're not talking about, you don't have a constitutional right to drive, for crying out loud. And again, we have evidence that can show that people who do A may be more likely to do B. This, however, took two very distinct and dissimilar situations, drug use and having a firearm, and said we are going to, in a very overbroad way, say there is all the time a nexus, a connection, and never mind what the Constitution says about one of the fundamental principles.
Right. And here's the other big difference between the situation that you brought up where you have someone who is convicted of driving under the influence, for example. When that happens, the government has to go through a process of proving that you violated the law. You have due process. You have a trial. In this case, Mr. Hemani had no trial, right? He had no proceeding in which the government actually proved he was dangerous. The government just categorically said, well, we've deemed this dangerous. Now, whatever anybody's thoughts are on marijuana, and I know this is a very divisive issue, take it out of the drug context for a minute. Put it into the alcohol context. Right? So let's just say the federal government passes a law that says, well, we've declared alcohol dangerous in every capacity, and so if you drink twice a week, you have one or two beers twice a week, well, you are categorically dangerous no matter what. Or if we take it into a thought police issue, right? To say, well, if you are a conservative Christian who believes in, biblical principles, well, you are categorically dangerous no matter what. That's just a very broad, sweeping power for the government to again, just categorically declare an entire class of people dangerous with no due process, with no individualized finding. And again, regardless of where you fall on any of the substance abuse issues or marijuana, this is a problem beyond that.
We're speaking with Amy Swearer. She is a senior legal fellow at Advancing American Freedom. They are online, advancingamericanfreedom.com. She's kind enough to join us live on the Newsline on News Talk 1540 KXCL. There are less restrictive means of controlling actionable behavior. In other words, you don't have to categorically remove someone's rights without due process. There were other ways that they could have made sure that Mr. Hemani was not a danger or a threat. Mm-hmm. And that's the hook on all of these, is it not? When there's a case of overbreadth by the government, there are less restrictive measures available to get at what the government claims it's trying to get at to begin with.
Absolutely. And this was a core component of the Supreme Court's decision, was to say, look, historically, right, when you look at historical laws that disarmed people like habitual drunkards, it was focused on giving them some sort of process by which the government had to prove, in the case of habitual drunkards, for example, that their drinking rendered them regularly dangerous or incapacitated. There are also, in states where marijuana is still illegal, and it's still very much illegal for recreational purposes at a federal level, they could have prosecuted him for the marijuana conviction. And then as a felon, right, he would have been disarmed. And I think what gets lost in some of this is this question of why was the government interested in pursuing this? Don't they have bigger fish to fry? It's funny that they pursued this case, Hemani comes to their attention because they're investigating him for potential ties to terrorism. Well, they end up not having enough evidence for that, and so they sort of use this other federal statute to get at him, disarm him for what they couldn't prove. And I think that's important here as well. They're essentially using this statute as a cop-out for the evidence they didn't have with respect to terrorism. And so you're right, there are just a number of other ways that the court leaves open here, including, by the way, the court explicitly says, look, this is not saying that there is no circumstance in which the government can't, look at a particular drug and conclude, that drug in that person is dangerous. For example, like someone who's addicted to methamphetamine. right? Or to demonstrate that, again, maybe Mr. Hemani was smoking an absurd amount of weed, and it made him specifically paranoid. Right? That would have been enough to show that. But again, it's about making the government actually prove its case that the person is dangerous because of this unlawful substance abuse.
In addition to the arguments that you've just posed, I always like, when I'm analyzing these things, to look at the impact if a ruling had gone the other way. So let's say, for example, in the U.S. versus Hemani case, decided 9-0 by the U.S. Supreme Court last week. What if the court had gone the other direction? What might have been the precedential impact of that in terms of encroachment on our rights?
Essentially, in a worst-case scenario, you could have read an opinion going the other way to allow the government to, again, just categorically determine, without ever proving, just to determine and pass a law saying, we believe that whatever category of person, whether it's someone who uses alcohol, for example, or someone who prescribes to a particular type of belief, that, well, we've determined categorically without ever having to prove that they're dangerous. Well, they're just dangerous, so we can automatically disarm them. We don't have to give them any process. We don't have to demonstrate dangerousness. We can just say, well, we think that there's this vague connection that sometimes some people who are Christians are also dangerous, or sometimes some people who, casually drink alcohol become dangerous. And so therefore, if you ever do this, you no longer have your right to keep and bear arms. And imagine what that would look like in the hands of, say, an administration or a state government that really doesn't like the right to keep and bear arms to begin with. You can imagine how very quickly that turns into this becoming just a way to disarm people under the guise of something being dangerous without having to prove it.
So it has come down this way. So what are the possibilities, again, having this as precedent, what are some of the possibilities either to blunt attempts from those who want to subvert rights, or is this a strong enough and broad enough ruling that it allows the possible challenge of other laws that are floating out there that would restrict constitutional rights from being fully exercised by law-abiding citizens?
So I think this, from a Second Amendment standpoint, is a really solid opinion, because, like we said, it doesn't go so broad as to say the government can never disarm anyone who's dangerous, but it does tie the test back to proving that someone is dangerous. So you take, for example, something like red flag laws, or even just, you have states like California. Again, it's just like one example, who will use what I would consider proxies to determine that someone is dangerous, where they will, allow as part of their test, well, did this person buy a gun recently, when they're looking at red flag laws? Well, that doesn't necessarily tell you whether someone is dangerous, right? And so I think this is good for federal courts to now be able to, not just be able to, but to have to tie back any analysis of laws that disarm people to a specific finding and demonstration that the person is dangerous. Now, that may seem like common sense to many of us, right? Because that would just seem to be what the only situation should be, that we should be disarming people. But again, you have a lot of states that are anti-Second Amendment in which that's not the case. They want to broadly disarm people. And so, if anything, this is a reminder to those courts that they have to tie this back to dangerousness and to proving that someone specifically is dangerous under the circumstances. So it's sort of prophylactic in that sense. And, it's not necessarily new. This is something the Supreme Court has said repeatedly in Second Amendment cases. But it is a good reminder, and it is a good standard of how this, we call it the Bruin test, how this judicial test actually works. Now, does that mean that lower courts are always going to follow it faithfully? No, unfortunately, but it is a good and I think a powerful re-emphasis of that principle, that at the end of the day, if the government wants to disarm someone, it can't just categorically wave a wand and say, well, anyone who does this is dangerous. It has to actually prove the specific person or the specific substance is dangerous.
Excellent analysis by Amy Swearer. She is a senior legal fellow at Advancing American Freedom. They are online at advancingamericanfreedom.com. I appreciate the insight in breaking this down into, as you know, some have tried to subvert the ruling to be a sky is falling situation, and it'd been far worse if it was the other way around in terms of impact on our constitutional rights. Thank you for the time, and we'll talk again.
Thank you.